Welcome to this week in Introduction to Corrections. For this, our last chapter, we're going to talk about the finality in the corrections system, those that have been sentenced to execution or the death penalty. In this chapter, we will discuss constitutional aspects and any case law rulings that have been regarding the death penalty. We'll go over and analyze the various statistics that have been associated with the death penalty and those who have received this sentence. We'll discuss the various methods of execution used in the United States and the various controversial issues associated with the death penalty. We'll also talk and identify the common philosophies related to the use of the death penalty and evaluate some of the correctional challenges that are associated with the inmates that inhabit death row. So with that, we will start with Chapter 17 and the final chapter we will cover this week in Introduction to Corrections. When we look at the death penalty, what we are looking at is the most extreme outcome that offenders can be given when they are sentenced and at the end of the correctional process. There are no rehabilitation efforts that are given to somebody who has been sentenced to death row, and therefore anybody on death row has no options toward treatment programs or rehabilitation programs while they are in this area of any facility. The true definition of capital punishment is very easy. It is putting an offender to death. And while there is a lot of information that can be covered within the scope of capital punishment and the death penalty, we're going to keep it relatively slim to just what we talked about in the previous slide. And we'll start by talking about the major decisions and the constitutional issues that have come up over the years since the death penalty has become a major sentencing option within our American justice system. The next several slides we will talk about the death penalty in regards to the Constitution, the constitutionality of the death penalty in regards to its allowability, as well as the limits on the death penalty through numerous decisions. There are a lot of court cases that we will be talking about. And while it is good to know all of the court cases, the ones that are the most important for you to be aware of, I will emphasize and let you know that these will be the ones that most likely will be on either quizzes or exams in the forthcoming weeks. When it comes to the death penalty, those being sent or sentenced to execution pretty much went unchecked for several years, hundreds, decades of years, as a result of the hands-off mentality that was entertained by the courts from the late 19th century into the mid-20th century, those span of years that we talked about when we talked about the legal issues that came into the correction system back in Chapter 3. But when it came to that hands-on period, that 20-year flourish of activity that the Supreme Court got involved with that started in the 1960s, we started to get a lot of cases regarding the death penalty during that time. And the first one of note was Trop v. Dulles. Now, Trop v. Dulles in and of itself was not a case that dealt with the death penalty in and of itself. But what it did was provide a phrase that would be cited in many of the subsequent death penalty cases and many other constitutional cases that came before the courts in years after. And that particular phrase was that evolving standards of decency that mark the progress of a maturing society. This particular statement is used by those that are opposing the death penalty, and in instances when it seems that questions of harshness or excessive sentencing are coming into the foray, only to remind not only those who are questioning the constitutionality of something, but society in general, that we have gone beyond the barbarity of generations past. And so Traub v. Dulles is supplying that reminder that we as a society need to continue to evolve, and that is what is marking society and having us move into a better and higher place as far as our expectations go. So even in today's society, people still will go back and cite that particular phrase from what now has become a 60-year-old case, just to remind everybody that we need to continue to evolve. The next major ruling that started to impact decisions on the death penalty is that of Witherspoon v. Illinois. The court determined that jurors could only be disqualified from serving on a jury that was deciding the death penalty if they were incapable of being impartial. Up until then, if they were having reservations, they were being allowed to be excused. The court said that was no longer the bar, that could not be the bar, that it had to be more absolute than that they had to be incapable of being impartial, because that's what we were requiring, was impartiality. And if you could not be impartial, then you could not serve and be able to give that type of decision. So with those two major decisions that started the ball rolling into what ultimately would be, in 1972, the major decision that put a moratorium on the death penalty as a whole. And this would be the major decision that you need to know. This is for your exam and quiz purposes, and that is Furman v. Georgia. By this time, it was starting to be established that how the death penalty was being administered, especially in specific geographic locations throughout the United States, that it was being meted out in a very arbitrary and what the court was describing as a capricious manner, which basically is there was no system. There was no fairness or equity into how the death penalty was being determined. And so you were seeing, especially in the civil rights era and the period of Jim Crow, many more minorities were being sentenced to death than non-minorities. And so when this was being brought to the Supreme Court, and it was a case out of Georgia, that because the death penalty statute and the wide discretion that was given to juries, and as a result, there was no guidance given to the juries on death penalty decisions. Being that this made the decisions on putting people into the death chambers and into death row too arbitrary, it made it a violation of the Eighth Amendment, which is another issue that we will talk about later on in this lecture, and therefore made it unconstitutional. At that point, when the Supreme Court decided that, it made the death penalty as a whole across the United States unconstitutional. As a result, this required that anybody in any state who was waiting to be executed on any state's death row to have their sentences commuted to life without parole. The Furman decision did not mean that the death penalty in and of itself was unconstitutional. That's not what the Supreme Court said. What the Supreme Court said was that the way it was being administered was unconstitutional. And therefore, if there could be a way that states could agree on a fair and equitable and less arbitrary manner that the death penalty could be administered, then the death penalty could be reinstituted across the United States. That happened with the reinstitution and the decision of Gregg v. Georgia, which is another case you will have to know. So 2 Georgia decisions, one took capital punishment away, one reinstituted it. We'll talk about Gregg in just a little bit. As mentioned in the previous slide, Furman v. Georgia placed a moratorium on death penalty cases, and while not ruling that the use of the death penalty itself was unconstitutional, ruling that the arbitrary and capricious use of it and that it was not equitable how it was being administered was the issue. Most of the states that had employed the death penalty as a sentencing option went about trying to rewrite their death penalty laws. As a result, 4 years later, Gregg v. Georgia was passed, which the Supreme Court said was sufficient enough to put the death penalty back as an equitable and alternative based on what was being presented. Now, it wasn't perfect, let me tell you, because there have been several rulings since then that were either narrowing the scope of what Gregg v. Georgia said or being more articulate on what was the expectation of Gregg v. Georgia. But in essence, in Gregg v. Georgia, which we've talked a little bit about in previous chapters, the idea that made the Supreme Court happy was to have a 2-phase trial when it came to allowing the death penalty. And so you would have the trial phase, which determined guilt or innocence, and then you would have the sentencing phase, which would determine whether the defendant was entitled to either death or life in prison without parole. And so Glossop v. Gross, which was just decided less than 4 years ago, was just one more challenge that came, and there have been others, several others that we'll talk about over the next several slides after this one, is the latest where the Supreme Court continued to articulate exactly what the expectations after Gregg v. Georgia meant. And this was just to let states know that when they were considering a method of execution, that the chosen method of execution is to be considered constitutional unless the convicted person can show that there is a substantial risk of harm that is increased through the given method when compared with another known and available method. Now, because this is only 4 years ago, the main reason behind this is the recent unavailability of the lethal injection drugs that we'll talk about later within this lecture. And so, because the standard drugs that had been used in lethal injection were no longer available, the states that had been using lethal injection had started to look at alternative drugs that had not been proven, had been shown to not have the same success as the other drugs that had been used previously. And so in this particular case, what the defendant or what the plaintiff was putting forth is that those drugs should then be discontinued because it was showing more risk than the previous method, and the alternative method, and we'll talk about alternative methods in just a little bit, was not as available either. And the courts were disagreeing with that, saying until you can show that there is a higher substantial risk, and in this case the court was not saying that the newer drugs were showing a more substantial risk, and so they were dismissing this particular plaintiff's argument and saying that those substitute drugs could be continued to be used. When the Gregg v. Georgia decision came forth allowing for the death penalty to continue, and the states started using it as as a sentencing option once again, it didn't end with the constitutional challenges. And so we had several, starting right after the reinstitution of the death penalty until just 4 years ago. And we probably will continue to see questions that come. These are some of the more important ones that we'll talk about over the next couple of slides. And the reasons that they are important are to either more clearly define the death penalty in and of itself, or to talk about specific groups that can be impacted within the constitutional limits of what the death penalty is expected to apply to. Now, the first one is Coker v. Georgia, another Georgia case, and the Supreme Court came down that the death penalty was unconstitutional when used for the sexual assault of an adult woman if she had not been killed during the offense. And so at this point, the Supreme Court is starting to recognize and narrow down what offenses are considered severe enough to be have the death penalty be used for. And at this point, the sexual assault of a woman without resulting in a death was not considered by the court to be severe enough to warrant being put to death. And this particular ruling by the Supreme Court was reaffirmed in 2008 by Kennedy v. Louisiana, and they accentuated this by saying even if the sexual assault involved a child. So by this time, the Supreme Court is saying, yes, this is a heinous crime. We're not disagreeing with that. But what we are saying is unless the sexual assault results in the death of that person, the defendant does not deserve. It's unconstitutional. It's considered excessive. It's excessive against the Eighth Amendment. They do not deserve death. As far as other types of decisions, in Ford v. Wainwright, this had to deal with those who were considered insane or extremely mentally ill. The Supreme Court restricted the use of the death penalty for those who were considered insane, and therefore the defendants who had successfully used the insanity defense could avoid the death penalty. Remembering that by 1986, not all people who used the insanity defense successfully necessarily meant that they were sent to a mental institution. We were starting to see a decline in the use of an insanity plea and starting to see more states passing what we call guilty but mentally ill, and therefore there were states that were setting forth on death penalty sentencing options in these particular instances. Another case that was significant was Atkins v. Virginia, which dealt with the execution of those that were considered mentally retarded or mentally handicapped, and those were also considered to be unconstitutional. Atkins v. Virginia is one that you should keep in mind for future exams and quizzes. This continues to be a very controversial issue. It was earlier because up until Atkins v. Virginia, the mentally handicap or incapacitation of someone was usually just used as a mitigating factor. And so it didn't necessarily rule it out, but with Atkins v. Virginia, it did rule it out. They were no longer eligible for the death penalty. Hall v. Florida took this 12 years later and narrowed the scope of that particular ruling by saying that if it's difficult to distinguish one's mental incapacitation, their disability, you can't rely solely on IQ scores to see whether somebody should be put to death. Now, if you remember in earlier lectures, we talked about what is considered to be a mental disability, what the IQ score is, and that's 70. And my question at that time to you was posed, so what really is the difference of a mental incapacity of someone who has scored on an IQ test of 70 and 69? Are you going to put the person to death at 69 but not 70? And so in Hall v. Florida, this is what that decision was basically saying, is that if you're having a difficult time distinguishing the mental disability, you can't rely on IQ tests alone. A person who scores 70, by definition in our court system, is supposed to be able to handle and understand the death penalty, and therefore would be eligible for it. And what Hall v. Florida is saying, yeah, you're going to have to look beyond IQ tests and see if that person really is eligible to understand what's happening to him. They have margins of error, and therefore you need to take everything as a whole and look at what we look to term totality of circumstances. When we look at other special types of offenders, we're going to move now to our juvenile population. And up until the mid-1980s, we didn't have much guidance when it came to executing juveniles. Thompson v. Oklahoma found that the 8th and 14th Amendments prohibited the execution of a person who was under 16 years of age at the time of their offense. And so it was only with Roper v. Simmons that this was solidified when they said the death penalty was unconstitutional with persons who were under 16 years of age at the time of the offense. And so with both of those, what we had with Thompson v. Oklahoma is only 4 of the justices fully concurred. And if you remember the makeup of our Supreme Court, there are 9 justices, and that is because they don't want a tie. So we can always have a majority ruling. With Thompson v. Oklahoma, if you only have 4 of the justices fully concurring, you're on the side of an almost tie. And so with Roper v. Simmons, you had a full court agreeing that juveniles were not considered culpable in the same manner that adults are and can't have the necessary intent. And therefore, this Roper v. Simmons, which is the case that you really need to remember when it comes to juveniles, is the often most cited case when it comes to the determination of juveniles not being able to be executed if they were under 16 years old at the time of their offense. So those are the key constitutional limits when it comes to the death penalty and its usage, and the ones that you need to remember for upcoming quizzes and tests. Other important decisions and issues that came up before the Supreme Court while all of these major decisions were being made also included more decisions based on equity and disparity. And so one of the biggest things that we still continue to grapple with when it comes to the arbitrary use of the death penalty is racial disparity. And the first time it was really dealt with was in Batson v. Kentucky, when the Supreme Court dealt how the juries are formed within death penalty cases. In this particular case, the court ruled that prosecutors had to provide non-racial reasons for eliminating potential jurors from serving on the jury. Therefore, having it put on record that race was not going to be a reason that was allowed to be a factor in the jury selection process. Up until that point, if you remember from your introduction to criminal justice class, during the jury selection process, prosecutors are allowed so many peremptory challenges and challenges for cause. But during the peremptory challenge, they are allowed to not give a reason. They can just say, no, I don't want this person. And if they have to give a cause, then it has to be something that is a necessary reason for them to not be on the jury. And what the Supreme Court said in Batson v. Kentucky is you have to give a non-racial reason why you don't want them on this jury. There was a lot of jury members who were being dismissed on black defendant juries who were being dismissed because they were black. And so there was a potential for all-white juries a la early 19th century serving on death penalty cases where the defendant was black. And so the Supreme Court says, yeah, you can't do that anymore. This was the first step in making sure there was less racial disparity and more of an actual jury of your peers being allowed to serve in death penalty cases. The next year came McCleskey v. Kemp, where McCleskey was a defendant who was trying to bring about these disproportionate statistics of how more minorities were being sentenced to death than Caucasians, and therefore he was not going to be able to get a fair trial. And the Supreme Court says, unless you can bring forth data that shows you personally are being discriminated against, it's not a valid data set. And so, yes, they agreed that this statistically, minorities are disproportionately susceptible to the death penalty. But his particular case, he could not show that that was going to have an effect on his case. And because of that, they disregarded his motion and his case. And so you could bring forth information and statistics if it has to do with just your case, not statistics in general showing racial disparity. Other types of Supreme Court decisions that were considered key in how the death penalty was going to be administered and continued also has to do with Ring v. Arizona, which is just in the last 20 years. In this case, up until this point, there were plenty of states across the United States that were allowing judges to be the ruling parties in death penalty cases. It was with this particular case that the Supreme Court laid down the ruling that juries needed to make this decision, not judges. And therefore, along with this, that aggravating factors, all aggravating factors, were going to increase the likelihood that the defendant would be sentenced to the death penalty. And all aggravating factors should be included in the initial indictment. They can't be added at a later date. So Ring v. Arizona had a lot of impact in that it required all the states, and there were a lot of states up until this time, that left the sentencing of the death penalty up to the judge. And therefore, it was after this that all of those states had to go back and rewrite their death penalty laws to leave that decision up to the jury, and therefore expand what the jury's position and job was in death penalty cases. So if you remember, we go back to Gregg v. Georgia, where it was determined that you had to have a two-phase process. And you had the trial phase, and then you had the sentencing phase. Well, what most states did was at the trial phase, that was in the jury's hands. They would decide guilt or innocence. But then what they decided to do was in the sentencing phase, they would dismiss the jury and they would have the judge decide death or life without parole. And it was at Ring versus Arizona that the Supreme Court said, no, if you're going to have the juries for the trial phase, you keep the jury for the sentencing phase also. And, oh, by the way, all of these aggravating factors that you think are going to be important for deciding death or life, you put them in the original indictment. Don't wait until the sentencing phase to do it, because you're going to have the jury understand what this means. That's the impact of Ring v. Arizona. Other U.S. Supreme Court decisions that deal with key issues when it comes to the death penalty involve representation and jury participation. And then the last one we'll talk about has to do with the place states have in deciding which defendants actually are eligible for the death penalty, even when that individual is a citizen of another country. So let's take first the important rulings that had to do with legal representation. As you remember from us discussing those civil rights, our Sixth Amendment right allows us to have representation. And when it came to the type of legal representation we are allowed, Strickland v. Washington defined that as representation that is objectively reasonable. So we all know that we can try and appeal if we feel that our attorney who represented us was in some way, shape, or form either ineffective or unreasonable in some ways. In Strickland v. Washington, what the Supreme Court ruled was that if they were going to demonstrate that their lawyer was not sufficient in their particular death penalty case, they had to also show that the ruling against them would have been appreciably different, meaning that the outcome would have been either no death penalty or even maybe not guilty had somebody with specific legal counsel been given to them. This lays into question the issue that really has long been one within not only the legal system but death penalty cases in particular, which is the use of public defenders to try some of these cases, especially with those that do not have the expertise or the resources to be able to defend some of these clients. And it's a very difficult standard to actually meet. The assumption when people leave law school is that they are trained and have the same knowledge as everybody else. And while we know that that's not the same, the realization is that some attorneys are going to have better knowledge, better resources, and better staff that are available to assist them with the defense of a defendant. And so while Strickland v. Washington set a standard, they set a very high standard on what was going to be allowable in order to say that you did not get your guaranteed Sixth Amendment rights. The next ruling to come down was McCoy v. Louisiana. This one was a little bit more in the defendant's favor in that the guarantee of assistance of counsel, which is what we are all allowed under the Sixth Amendment, they went on to specify that it does not mean that just because you have counsel does not mean that you give all of your decision-making to that counsel. In other words, if you have an attorney represent you, you still have all of the decision-making when it comes to plea agreements, waiving rights to trial by jury, appeal rights, and anything like that. And it was this particular case where the defendant in the trial was claiming innocence and stating that he wanted to go to trial. His appointed counsel pled guilty for him. And the Supreme Court says, yeah, you can't do that. You are only his appointed counsel. You have to go by what he says because this is his trial. You are there to help him and to guide him. And so it was with that they actually said that his Sixth Amendment rights had been violated because the attorney overreached his boundaries. In the next case that had some significance to it in that it is showing some contradictions to an earlier case that we talked about, and that's Utrecht v. Brown. And in Utrecht v. Brown, it held that the trial court could remove potential jurors from service if they said they were doubtful that they could vote in favor for the death penalty. That they were not in opposition to it, but they were doubtful whether they could vote for the death penalty. And this was in direct contradiction to what Witherspoon, in an earlier case, had said, which was that, no, it had to be an absolute before you could remove a juror. This is pretty common, and therefore we might need another case that's either going to go back to solidify what Witherspoon is or further erode it by agreeing more with UTECT. And so we'll have to kind of watch what happens in later cases. The last one has to do with foreign nationals who are accused of a crime in a state jurisdiction, and the state jurisdiction decides to go for the death penalty, and the foreign government that he is a citizen of fights the government to not have him put to death. So a little background. We all know that the southern border has quite a few illegal immigrants that come into the country. This is one of those cases. In Medellin v. Texas, Medellin was arrested, convicted, and was set to be put to death as a Mexican citizen who had sexually assaulted 2 young girls. Now, even though earlier we talked about the fact that the Supreme Court had changed its laws to not allow the death penalty in the case of sexual assault, as we'll see in later slides, there were laws that were passed later that started to allow these exceptions. As a result, he was convicted and sentenced to death. Mexico, as a result, sued the United States and said, we don't have the death penalty, and therefore we don't want him put to death, and you don't have the right to put him to death because he's not your citizen, he's ours. And by the way, you didn't inform the Mexican National Consulate that he was even under arrest. That's a problem. State of Texas said, that's too bad. He was on our soil. He committed a crime in our jurisdiction. We're staying put. The United States government actually tried to get the Supreme Court involved on behalf of Medellin, because to actually take these steps that Texas was taking was a violation of the Vienna Convention, which didn't allow this. Bad precedent to take. When you think about it. It would be putting the United States in the breach of its obligations, especially to comply with the oversight of a world court, which is an international court that the United States takes part of. And Texas was steadfast in saying, we have a right, we are a state, and we have a right to our authority to implement our judicial decisions in our jurisdiction. As a result of this case, the United States ended up withdrawing from the Vienna Convention's optional protocol in the International Court of Justice. And Medellin ended up being executed. The International Court of Justice did ask for a stay of execution. It was denied, and the defendant was executed per Texas's protocols later that year. What this does over the course of politics within the coming generations, we won't know. As we will talk about, the United States is still one of the few countries that is considered to be highly civilized that has the death penalty in existence. And so whether it would result in a tit for tat with another country, we won't know until they're put in that position. But it's a very bad precedent to set. And Texas did it just a little over a decade ago. Some things to keep in mind when we talk about people that are on death row. is that while gathering statistics is always going to be controversial, we need to keep in mind that those that receive the death penalty as a whole, compared to the entire population of those that are in correctional facilities, are a fairly small percentage. It never really goes above about 300 and has been consistently going down over the last decade. When it comes to those that are actually carried out, we're looking at, in the years since the death penalty was reinstated in 1976, less than 1,500 people have been put to death and executed in that amount of time. And this isn't to say that it's not a big deal, because the death penalty as a criminal sanction is always going to be a big deal. But to keep it in perspective, when we have 2.2 million people, or between 1.6 and 2.2 million people in our correctional systems, then the number of less than 1,500 or 1,477 that have been executed in the span of 36 years, 38 years, that's a very minute number. And if you took the entirety of this particular population, it would be less than 1/20% of the prison population. And we're talking about a very infinitesimal amount. So why is it that it creates such controversy? And we'll talk about that as we continue on. If we look historically at it, there are going to be some things that actually come out. 3 states have the largest death row population across the United States: California, Florida, and Texas. And that's not surprising, because those are 3 of the biggest populated states in the Union. They're also part of the top 3 in correctional institutions due to the size of their correctional populations. The death penalty itself is relatively minimal in regard to the day-to-day operations in the criminal justice system. But one thing we have to know about, and I've said this before, it is extremely costly to maintain. And if I haven't brought this up, I'm going to explain it now. Somebody who is brought through the system on a death penalty case and the prosecutor seeks the death penalty is going to increase the amount that is going to be spent within the correctional system almost exponentially. So you have a person who is sentenced to death, comes into your correctional facility. Number one, their security level automatically goes up. They are now going to have to be housed in a special institution, in a special area with special staffing. On top of that, they are also going to have the opportunities for the appeals to go through the system to try and keep them from being put to death. That is an automatic based on our legal system. On average, they are allowed or will be on death row anywhere from 15 to 20 years or more, because appeals don't come fast and they don't come cheap. On top of that is the cost of the execution itself. And so when you put all of these costs together, it becomes one of the more expensive expeditions to have as part of your correctional philosophy in your state. The southern region of the United States is going to be the most punitive in nature. So you're talking the areas of Florida, Alabama, Georgia, Texas, Mississippi, those areas, and a little bit north, and then Arizona, New Mexico, Florida are more apt to have the death penalty and use the death penalty with regularity. Those are just some of the statistics that we'll talk about now. And the more you study the death penalty in your subsequent classes, you'll find out just a little bit more. When we look at death row, defined, it's going to be people who have been sentenced to be executed but are awaiting their execution, and we need a place to put them. And so let's take a minute to look at some elemental statistics of who exactly is on death row and what that means. As of 2013, which is about 6 years ago, and the last time we had available statistics to us, about 3,200 people were on death row. Most of them were male, almost a little over 98%, and that leaves less than, or just less than 2% are women, and we'll talk about them in just a minute. When we talk about race in the next slide, we'll delve into this particular statistic, but believe it or not, about 55% of all inmates on death row are white. About 41% are African American, and then the remaining are of some other identifiable race. About half of offenders don't have a high school education. And we talk about, and have continually talked about in all of the chapters, whether it's about prison life, probation, parole, intermediate sanction, whatever it is, we talk about the need to bring educational services into our correctional systems because of the persistent educational deficiencies in our inmates. This goes into and includes our death row inmates. Some interesting things. The average age of people on death row is about 47, so they're a little bit older. About 16% are 60 years or older, and about 8% are older than 65. Take into consideration what you think that's going to mean. We equate violence and we equate security issues with those that are young. And if you have 25% of your death row inmates 60 years and older, and you have what in essence is 75% of your death row population almost 50 years and older, which in earlier lectures we identified as the elderly population, maybe we should talk about whether the security issues should be relooked at, even if they are on death row. As of 2 years ago, only 53 women were on death row across the United States. Only 16 have been put to death since it's been reinstated in 1976. Some of the more famous ones that you can look up, Karla Faye Tucker, who was the very second one to be put to death, but that wasn't until 1984. And then Eileen Wuornos, who was one of the very first female serial killers, and she was put to death in Florida. Half of the women who were put to death between 1976 and 2015 are from either Florida or Texas. And the majority of women awaiting execution throughout the United States are Caucasian, over 75%. So now let's look at racial disparity within death penalty cases. So as I mentioned in this slide before, statistics show that more whites than minorities are executed within the United States. But when you actually can delve into a little deeper what this means, what you need to also consider is that when Caucasians, and you look at the statistics of Caucasians and African Americans, you also have to look at the percentage of this population in the outside world. And so yes, 55% of the population who are of the correctional population that are executed are white. 41% are African American. But just like when we talk about incarceration numbers, we have to keep in mind the number of the population that they represent in the nation. And so when you recognize and understand that when you're 41% of the population, not only in the prisons, but that's the number that you represent in executions, but you represent only 13% of the population, you are overrepresented, and that is racial bias in its application. Because of this, and a lot of people who don't know how to interpret or research statistics, this is where we get some of our contention that the death penalty is administered in not only a racially biased manner, but also in a class biased manner. Because of how people can afford representation, and also in some other ways that needed to be decided by the Supreme Court, in which we talked about earlier within those key cases that allowed for, number one, the rewriting of the death penalty laws because of how death penalty cases were being arbitrarily and capriciously decided. So you started with Furman v. Georgia, had it retooled, reworked. Gregg v. Georgia said, this is how we're going to do it. Supreme Court said, fine. So now what we're seeing is that the issue of discrimination has been shifting a little bit. And the contention is that if you are a white defendant who has killed a black person, or a black defendant who has killed a white person, you're going to see significant differences in how those cases are going to be prosecuted. If you take a moment to look in your book at the chart, you will see that there is a propensity to think that there is racial bias in how they are decided. And so those are some questions that continually have to be answered. And I don't have more than the availability of the research in front of me to give you any more answers. That would be something you on your own would have to look into to help you answer those questions. By initial observation, it does point to some bias in the system. So now what we need to do is look at where that bias starts, where in the system it begins. The decision to seek the death penalty comes from the prosecutor's office. In states that have the death penalty as a sentencing option, that decision to put the death penalty as part of the case is decided at the time the charges are filed. If at that time the prosecutor decides not to seek the death penalty, nobody will know that that was a sentencing option. And therefore, the jury, at the time the trial goes on, will not be aware that that was a sentencing option. And so what happens is we have what is known as prosecutorial death discretion. At its core, this observes that prosecutors across the nation are overwhelmingly white and seek the death penalty disproportionately when the victim is also white. What we also need to realize is that most prosecutors are voted into office. And with this comes the political realization that they could be tempted to ensure that affluent members of the community remain satisfied so that they can continue to be voted into office. The bottom line then, which can result in class as well as racial bias, is that minorities and lower socioeconomic classes tend to have fewer resources and in return less political clout for their voices to be heard. I'm not saying that this is the way that things should go, but what supporting research has meted out is that prosecutors who do make these decisions, whether implicitly or not, end up with some supportive bias in how death penalty cases are decided. And more research needs to be done in order to figure out a way to combat that. So far we've covered the constitutional aspect of the death penalty and how the decisions that have been made within the last 50 years or so have narrowed the scope and made key points in the usage of the death penalty really important in several ways. For the next several slides, we're going to now focus on not only the way the federal government uses the death penalty and how that impacts the states, but then we're going to transition into how the death penalty is carried out and move on from there. The thing we need to remember is that prior to the establishment of the Bureau of Prisons in the federal government, anybody who was charged with a federal crime would be housed within state prisons. We covered this in previous lectures. But the establishment of the death penalty as the ultimate punishment to be carried out was first passed in 1790 for a lot of offenses that, if it were to be considered today, would not be part of constitutionally acceptable reasons. Things like forgery, piracy, counterfeiting, things that happen in areas that we don't consider to be possible, were considered part of the death penalty scope. Now we know that those that go through a death penalty case have two hearings. They have the trial phase, and then there's the hearing to determine whether the death sentence is justified, and this happens within the federal court system. Per the previous court decisions, this hearing is going to be held before a jury of 12, and the prosecutor is going to present evidence that will either support a decision of death, and these are going to be in what we call aggravating factors. Now, if you recall, we talked about the difference between aggravating and mitigating circumstances that could help determine whether a person is more culpable and should receive the death penalty or not. The prosecutor is only going to be interested in presenting aggravating factors. These are going to be those that not only were previously in the indictment so that it's expected what's going to be heard, but those are going to be the things that are supportive of the reason for the death penalty. Those that are going to support and prove that they are more culpable and therefore should be receiving the death penalty. Now, on the other side, the defense is then going to want to present those mitigating factors, those things that the jury should consider as a way to present as less culpable or an explanation, more or less, and therefore consider the defendant to be less likely to receive the death penalty. The jury, in order to recommend the sentence, must determine whether there is enough between aggravating factors to outweigh the mitigating factors. If there is, then they can recommend a sentence of execution. There have not been many in the federal court system who have received a sentence of death, because as of just 2 years ago, there are only 63 inmates on death row in the federal correctional system. Pretty even among Caucasians and African Americans. There is only one female. As we know today, there is one federal death penalty that was passed in 1994. This laid out the procedures that were constitutional for the imposition of the death penalty. They have laid out 60 offenses under federal capital statutes that fall into 3 broad categories. So you're going to have a category of homicide offenses, a category of espionage and treason, and then a category of non-homicidal narcotics. Under these 3 broad categories, you will have the 60 offenses that will be categorized under these 3 broad tiers that will be under consideration for who can receive the death penalty. After the Federal Death Penalty Act was passed in 1994, the Anti-Terrorism and Effective Death Penalty Act was passed in 1996. All this did was actually add more federal offenses to the list of capital crimes. What this does is prove that the federal government not only is very serious about using the federal death penalty as a possible sentencing sanction, but that they understand that with the changes in the criminal justice system and changes in society, that there needs to be continual and substantial revision within the federal justice system. Between the Federal Death Penalty Act and the Anti-Terrorism and Effective Death Penalty Act, they came up with a protocol. This lets everyone know under how the process is to work between the U.S. attorneys and the court system. Basically what happens is the U.S. attorneys, who are the prosecutors, quote unquote, of the system in the federal courts, they need to make sure that they submit for review all cases in which a defendant is charged with a death penalty eligible offense regardless of whether they are actually going to seek the death penalty as a sentencing option. These submissions are then going to be reviewed by the senior federal attorneys at the Attorney General's office. They have a committee that actually reviews these, and then those will be reviewed and making a recommendation to the U.S. Attorney General. As a result, a very small percentage of the cases that are sent for review are actually sent back with a recommendation for the death penalty. When we look to see where exactly the penitentiary that is used for those that are awaiting carrying out of executions within the federal prison system, we only need to look to a state very south of us. United States Penitentiary Terre Haute, which is located in Indiana, is the physical location for federal death row. They have only been modified within the last 20 years to accommodate death row inmates and provide what is necessary to be able to handle the security functions for those awaiting execution. Now we're moving to how executions are carried out. Generally, there are three primary means of executing offenders on death row that are used throughout the United States. The most common used, and we'll get into the specifics of it in just a little bit, is lethal injection, brought into commonality in the late 1970s. There's also using electrocution, which we'll also go into in a later slide, which is use of the electric chair. The third most common, which is only used sparingly, has been the use of the gas chamber or lethal gas. Now, there are some states that do use other types. There are a few states that have chosen to use the firing squad. And there are a few states that still use hanging, which is a holdover from the 18th century and before. It's very rare and only authorized as a means in 3 states, Delaware, New Hampshire, and Washington. So now let's take the opportunity in the next several slides to break down the primary ways of execution, how they're carried out, and what it means by using each of these methods. The most common method of execution is lethal injection. The protocol to use for lethal injection is 3 drugs: sodium thiopental, pancuronium bromide, and potassium chloride. To use these in a specific order will render the inmate unconscious and then unable to breathe and then have cardiac arrest. The sodium thiopental is a barbiturate. This is what will cause the prisoner to become unconscious. Pancuronium bromide is a muscle relaxant. With that, the muscles will relax, which in turn will paralyze your diaphragm and lungs, making it impossible for the body to breathe. Finally, the potassium chloride is then what will be the final issue with the body, which will cause cardiac arrest. Each chemical that is administered is lethal when it's done correctly. The protocol for lethal injection as execution starts with the inmate being escorted into the designated execution chamber, making sure that he is secured into and onto a gurney and then restrained by ankle and wrist. They make sure that he or she is connected to a cardiac monitor to make sure that they can know exactly when he is no longer alive. And they start out IVs trying to find usable veins. When the warden gives the signal, they start with the injection of the different intravenous chemicals. One of the most common problems that will be encountered using lethal injection is being able to find a vein that has not been destroyed by chronic drug use and being able to properly insert an IV. Currently, we have 20 states and also the federal government that authorize lethal injection as the sole method of execution. Sole means that there is no secondary option. The other states that have capital punishment have it as a primary method, but have other alternatives that are available depending on the choice of the inmate. It is those other alternatives that we will look to now. Electrocution has been part of capital punishment for over 100 years. Since the invention of electricity back in the late 19th century, the idea of using electrical current to execute somebody has been part of the criminal justice correction system and a method that continues to be used in the United States. Thought to be more humane than previous methods when this new type of invention was discovered back in the 19th century, what has been discovered over the years are several problems that we will discuss in just a moment. For somebody who is or has chosen electrocution as their means of capital punishment, the protocol tends to be the use of a wooden chair that will then restrain them at several parts in their body that have connections to an electric current. There is an execution chamber, and the chair usually is constructed of some sort of wood, usually oak, that has been set on a rubber matting that has been bolted to a concrete floor. There is an anklet that is laced to the offender's right calf, and a sponge and an electrode are attached. This will be explained why in just a moment. The headgear consists of a metal headpiece covered with a leather hood, which will conceal the offender's face. The metal part of the headpiece consists of a copper wire mesh screen to which the electrodes are put upon. A wet sponge, again, is placed between the electrode and the offender's scalp. When the safety switch is closed, the circuit breaker then becomes engaged, and the execution control panel is then activated. Some of the most common problems that are encountered when using the electric chair are going to be some burning to different parts of the body or a failure to proceed because death does not occur without several shocks instead of just one. There have been many accounts over the years of botched executions, and this is also one of the reasons that lethal injection was chosen as a replacement for electrocution. Nebraska currently is the only state that uses electrocution as the sole method of capital punishment. They do not have an alternative. They chose not to use lethal injection. In 2008, the Nebraska Supreme Court ruled that the use of the electric chair as a method of execution does violate the Nebraska Constitution. Because there is no alternative method, that means that right now, Nebraska is practically without a death penalty. The introduction of lethal gas as an alternative to either hanging or electric chair was something that was introduced also at the beginning of the 20th century. The idea behind this is that you bring somebody into an airtight chamber and place them in a chair, restrain them in that chair, have them wear a mask, and then underneath the chair is going to be a metal container. After they are secured in, the metal canister on the floor is opened and filled with a sulfuric acid solution. When everybody is out of the execution chamber and the only one left in is the inmate, each executioner turns the key. When the 3 keys are turned, the electric switch then causes the bottom of the cyanide container to open, allowing the cyanide to fall into the sulfuric acid solution, which is what produces the lethal gas. Unconsciousness can occur within a few seconds if the inmate takes a deep breath. Now, this is where the tricky part comes in. What's the first thing that is innate within us if we know something bad is going to happen that's in the air? We're going to try and hold our breath. And so that's a reflex within us. And so a lot of times that's what people do. If the inmate holds his or her breath, then it's going to take longer. The heart monitor that is attached to the inmate is then read in the control room, and death can take anywhere from 6 to 16 minutes depending on how long it takes for the inmate to take a breath in, to fall unconscious, and eventually for the heart to stop. The most common problems that happen with execution by lethal gas are going to be the length of time, the agony that's caused by the convulsions and the things within that 6 to 16 minute time span. Right now, we only have 4 states that authorize the use of lethal gas, and it is as an alternative. One of the reasons that lethal gas is not used is that while it became a principal use in the early 20th century, it was during World War II and shortly after, with the discovery of the death camps from Germany, that it was decided that that might not be the best way to publicize executing prisoners, and the use of lethal gas started to fall by the wayside. Right now, Arizona, California, Missouri, and Wyoming are the only ones to authorize as an alternative method the gas chamber as a means of execution. Their primary method is lethal injection. For as long as there has been a death penalty in the United States, there have been those that argue for the death penalty and against the death penalty. And while there are plenty of people who might not have an opinion about it, we are going to always find people that have very strong feelings both for and against. The next part of this lecture are going to focus on those that have strong opinions for the death penalty, and we'll discuss those arguments for the death penalty as it regards to deterrence, retribution, and then we'll take a look at one argument against the death penalty, and one that comes up quite often, which is the arbitrariness at which the death penalty is meted out. If you recall, in the very early parts of our semester, one of the first philosophies that we talked about, and one of the first ideas that we discussed, was the idea of deterrence. How to get offenders to not continue to commit crimes. And we discussed both specific and general deterrence. Those that support the death penalty as a means of sentencing options are always going to say that it has a deterrent effect. More so as a general deterrence, in that if you sentence somebody to death, then it lets the general public know that the ultimate punishment for the crime that's committed will be that they can be put to death. As far as specific deterrence, the specific deterrence is achieved by sentencing that person to death, therefore letting them know they will never be able to commit that crime again. And while that obviously is going to be the case, as far as general deterrence is concerned, the opponents argue that there really is no evidence that the death penalty lowers crime. In fact, there may even be in some research that in areas where death penalties are carried out, that it can increase crime. And we'll discuss this in a little later slide. Most of the people who actually commit capital crimes such as murder, well, they don't plan on being caught. So the idea of them actually entertaining the idea of being put to death doesn't enter their minds. So the fact that having execution as a deterrent is not something that we see as a logical framework. It doesn't enter into the offender's mind when they're committing these crimes. Also, what can be argued as far as the opponents are concerned is that life sentences without the possibility of parole are just as effective as death sentences, because it can deter crime in a general and specific manner. The life sentence allows for the remediation in cases where, if there was a possibility that the offender was innocent, it can be proved. And with the advent of DNA, we've had that occur on several occasions. And as we've talked about earlier in this lecture, life sentences can be less expensive than death sentences, especially when it comes to actually carrying out the execution. And as you'll find out in many classes, those that are serving time on death row tend to be less violent, more well-mannered, and really don't represent any sort of institutional hazard. And so when we delve into security measures for those on death row, we really should look at that from a research aspect. The second argument for the death penalty centers around the concept of retribution. Now, it was talked about earlier in the semester when we covered philosophies again. The idea is centered around an eye for an eye. The idea that the offender committing the crime should be punished with the severity of the crime that they had committed, or what we termed back in Chapter 2 as just deserts. So, in essence, the punishment should be matched with the degree of harm that was caused. And while many people confuse retribution with revenge, it really is not that simple. Retribution is based on the idea that if a person commits an infraction, that the logical penalty should be within the same severity of that infraction. And so people who argue for the death penalty say if you take a life, then in exchange, the logical consequence should be you give up your life. Families of the victims can see that. Some communities see that. However, opponents of retribution simply see it as revenge or vengeance. And if we go back to some of those key Supreme Court cases that we talked about earlier, then we have to go back to that Trop v. Dulles. And that small statement that opponents will bring up when it comes to the idea of using the death penalty, and that the use of the death penalty is going to contradict the idea of evolving standards of decency that have marked the progress of a maturing society. So opponents are saying, yes, okay, retribution in theory says this, but haven't we grown as a society to not need that eye for an eye, to not need that revenge? And so opponents will say, we've evolved beyond this. We need to get beyond the need for this. And so you have two very differing sides of this argument. The last argument within the death penalty is known as arbitrariness. The idea of arbitrariness has been part of the death penalty argument for decades. Supporters of the death penalty say it is not applied equally or fairly. And even though we note that Caucasians are executed more than minority offenders, remember in an earlier slide, I cautioned about noting the differences in the population in the world versus the percentage of offenders who were executed. And so we do see a higher number of African Americans that are executed compared to their overall population numbers. We also have to keep in mind that in a criminal justice system that relies very heavily on the art of plea bargaining, where 90 to 95% of all criminal cases are plea bargained, then what we need to realize is that determining whether the offender gets the death penalty has little to do with the outcome of justice, but is reliant on other factors that come with the case. And so this also is going to create potentially arbitrary outcomes. The problem still remains is that a lot of general consensus is that we can never calibrate or make a sanction such as the death penalty to be exactly what the crime is to the sanction that it needs to be. And the ability to make sure that there is this type of exact proportionality is what undermines and makes invalid the argument that retribution is what we need for the death penalty. And this is what the supporters of arbitrariness will continue to say as long as we see in research the higher or disproportionate percentages of minority offenders compared to overall population numbers when it comes to the use of the death penalty among the minority community. The last thing we're going to cover when it comes to the death penalty is what happens with life inside the secured areas of the institutions that have inmates awaiting execution. And while we've done some research of the areas and what happens to those awaiting execution, living out their lives in these areas, we've also found some research that the death penalty may not be deterring crime, but actually increasing homicide levels or capital crime levels where the executions occur. We mentioned this when we talked about specific and general deterrence in the areas where there are execution chambers. This is called the brutalization hypothesis, and the contention that the use of harsh punishment ends up desensitizing people and therefore teaches them violence, and therefore they use it. Now, of course, you're going to have research that shows evidence that it exists and research that shows that it doesn't exist. And what we have are two separate sets of findings that show this itself. Mann in 2017 shows that not only is it questionable as to whether the death penalty deters crime, but that there may be some evidence that it actually aggravates the likelihood of future crime. He completed research over 5 years and compared the death penalty states that actively use the death penalty. So we're talking California, Texas, Florida, Oklahoma, with other states that did not use the death penalty, and found that those states that use the death penalty, on average over the 5 years that he did his research, had a statistically significantly higher violent crime rate per capita than those states that did not. What these findings did led to the following additional saying: that lawmakers should consider alternate theories focused on social issues, economics, opportunity, and other control theories in their crime control policy. That based on what he had researched, it is possible that the death penalty has an opposite effect to deterrence. And so we need to take into consideration that the idea behind the brutalization hypothesis is that if you live in a place like Texas, like California, and you see the death penalty being carried out, it's not seen as a deterrence. It's seen as a green light to be more brutal, that you become desensitized to the idea of what happens and therefore take freer license. And that's what his research showed him. Now, not all people actually abide by that, and so more research really needs to be done. So what is life like inside death row? Some research has been done in this and have come up with two specific terms that you need to be aware of. Research done by Harrison and Tomeny have come up with the ideas behind the psychological issues that are faced by our offenders that spend an inordinate amount of time on death row, which results in their solitary confinement and isolation over the course of not only years, but sometimes decades. One is death row phenomenon, which is the harmful effects of death row conditions that are experienced while waiting for one's demise. And what this phenomenon is not unlike what solitary confinement is for those that go into discipline, only this has the added extra of contemplating continuously the fact that you are awaiting your execution. The other thing that has been coined during this research into living on death row is the idea behind the death row syndrome, which states that mental illness can develop over time as a result of death row phenomenon. So these two types of concepts are going hand in hand as a result of excessive amounts of time in solitary confinement. And if you didn't go into death row persistently mentally ill, chances are that you will end up exhibiting signs of mental illness the longer that you stay on death row and have to deal with and contemplate your eventual execution. There have been other reports and other research regarding this, and have found that there are debilitative effects of housing death row inmates within specific security housings. Not only does it affect the inmates who are housed on death row, in that they have extreme deprivation, isolation, helplessness that result in things like PTSD, psychosis, depression, but it's also going to have an effect on the officers who work in that area because of the fact that they will not only form relationships, but there will also be hostility, manipulation, difficult relationships with other officers because of where they work, which then will also result in a lack of support from administration, and also having role conflict in difficulty fulfilling job role expectations. And so we have to remember that while the initial idea behind housing inmates who have been sentenced to death in a super secure area, what we've uncovered during this type of chapter is that, number one, most of the inmates on death row are entering the elderly category. They tend to be nonviolent, and they, during the time that they spend on death row, have developed syndromes that will make them mentally ill due to the extreme isolation and contemplation of their eventual execution. Add to that the personnel that have to work in that area and the psychological and stress that those officers have to go through, and you have a death penalty, death row area that is extremely hard on both inmates and staff alike. And more research needs to be done on how to better manage those areas in order to both assist with the stress levels of the officers working in that area and learn how to better manage the inmates in that area. This concludes the chapter on the death penalty. And while it was a quick overview, introduction to the death penalty, we did cover the constitutional aspects and a lot of case law. Remember that the cases that I emphasized are the important ones that you need to know for your final and the quiz for this week. We analyzed various statistics and looked at the death penalties and those who received the death penalty as a sentence. We covered the various methods of execution that are used, primarily the top three, and the controversial issues that are associated with the death penalty. We looked at the common philosophies, primarily deterrence, retribution, and arbitrariness, and looked at some of the correctional challenges, especially death row phenomenon and death row syndrome, along with the brutalization hypothesis. Your last case study for this semester can be found on page 508 in your text, What Would You Do? Read the scenario thoroughly, and then make sure that you answer the question, what would you do, using chapter references and your own opinions. Make sure that your answer is no less than 300 words, and then make sure you go to another student and comment on their answer. I have enjoyed this semester with you. I hope you have received a good education, a good amount of knowledge, and I hope to have you in another corrections class. Thank you for your attention, and good luck.